So hello everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law, and today we're talking about constitutional law. So there are it's a very wide course, very wide curriculum, and people really get bogged down by constitutional law. I know myself, it was the exam that scared me the most because it is very abstract in its interpretation and it's very much based on politics and knowledge of Irish society. But yeah, I'm going to go through a few tips today. I'm also going to look at the March 2024 exam report and just see can we learn anything from that. I've just updated the 2025 FE1 ebook with the October 2024 exam questions, and yeah, let's just get into it. So first of all, when it comes to constitutional law, people generally do pass it. So the first one is around constitutional interpretation and approaches. So understand the different constitutional interpretive techniques used by Irish courts. So for example, there's the literal approach, which is the plain language approach, which was seen in the People DPP v O'Shea. Then the second one I would say is the harmonious interpretation, which emphasizes a more holistic or broader constitutional context, and that would be McGee versus AG. And then I suppose the most controversial one is the natural law approach, which is the opposite to legal positivism, if you've ever studied that in jurisprudence. And natural law is law that derives from moral principles and natural rights, usually stemming from a religious philosophy. So in Ireland, at the start of our constitution, there's reference to Almighty God, but it's not a secular constitution. There's not a clear divide between church and state, even though there should be, and we know that because of indirect discrimination when it comes to baptizing for secondary schools. There's a clear bias towards denominational schools who are funded by different religions and their admission policies. And yeah, you will see again McGee also definitely touched on the natural law approach. Remember, that one was around the contraceptive jelly. But I would say that in every single constitutional paper you're going to do, even if you're directly not asked about constitutional interpretation, you still really need to know it. And again, I'm just mentioning McGee there, for example, that is a classic case of unenumerated rights. You need to find out what they are. Basically the rights that are not expressly written into the Constitution. Crotty v on Taoiseach, that would be another one. Non-delegation, and then Hennigan v Minister for Housing, for example, that was a rejection of the literal interpretation. So yeah, you just kind of need to know certain landmark case laws, but you will have learned these in your undergraduate. The other kind of interpretive piece of knowledge I would say that you need to have is, well, two of them. There's the presumption of constitutionality and the double construction rule. So the presumption is just know how the courts presume that legislation is constitutional unless proven otherwise. So take a look at TOG versus AG, and then you need to understand the double construction rule, which is where courts choose constitutional interpretations where possible because of the presumption of constitutionality. And that was seen in MacDonald v Board Nagan. It came to, I think it was describing an administrative body or tribunal. Yeah. I already mentioned unenumerated rights, and Articles 40 to 44 has personal rights. Or newer kind of emerging rights, I would say one is definitely environmental rights, as seen in Merriman v Fingal, and one which the examiner is particularly fond of is if there is no such right to housing, but it is almost implied by the Constitution, and there's been some case law around that as well. And the other two concepts I would ask you to also take a look at is mootness under McDade v. Sheehy, and having locus standi. Now, the locus standi, or having sufficient interest in the case, is really important, and the examiner has actually mentioned that in the March 2024 exam report. And I think it's actually quite nice. So the examiner says, as a general note, this is a recurring issue where candidates fail to consider or refer to the legal basis of the claim being made. It is important to remember that a claimant in constitutional litigation must invoke some kind of legal interest before the courts will move to consider questions such as whether the interference with that interest is justified, or what remedy might be necessary to vindicate that interest. So before you can talk about interference with a right, you have to establish a right, is what the examiner is basically saying, or a claim, indeed a constitutional claim to be made. It may be useful for candidates to remember to ask themselves, and this is what I always say when I'm teaching constitutional law, is what is the right or legal principle being relied on to bring this case? That is your first port of call when you're answering any constitutional rights question. So when when the examiner was talking about question 6 of the March 2024 paper, urged the examiner that some candidates simply stated that Etna has a right to housing, and in an absence of a more comprehensive analysis of whether such a right might be recognisable, these candidates received a lower mark, because obviously you have to establish the right. If it's an unenumerated right, you have to establish it properly. So the next one I would say would be know the grounds of judicial review very well, like proportionality or irrationality, and also beware of the non-justicable matters like Oireachtas discipline, a la Hallelujah v. Moylan, or foreign affairs, which is Crotty v. Taoiseach. Also, a big part of the exam is examining the consequences of unconstitutional legislation. So, for example, the balancing of rights and public policy, as was seen in Murphy v. AG, and compensation claims and their limits, as was seen in A v. Arbor Hill. And so the other thing I would say as well from the constitutional FE1 is don't do the case law question. Last March there was a question on journalistic privileges, and the examiner kind of complained that people's knowledge wasn't up to date. We don't obviously have the exam report from October, but I'm just looking at the questions here. So the first question was around Article 42A. The second question was around, so it's one of those classic how you're treated in a Garda station and trial in due course of the law. Question 3 then was around, so it's a company looking for advice to challenge an act. So basically it's a sugar company, and their sugar's essentially being taxed, and it's making it impossible for them to sell it. I think we've seen one of those before. That kind of comes around your property rights and that kind of thing. Then there's also one on constitutional justice principles, somebody being dismissed, their right to be heard, and all of that. And then there's an essay question 6, around non-delegation doctrine. There's a referendum question around government allocation of funds. And then the last question is European Charter of Human Rights, and I don't do human rights in constitutional law. But yeah, the majority of the paper is constitutional rights. Usually 4 questions, I would say, and then the rest is kind of principles around like separation of powers and like the running of the state. It's kind of a nice mix. But yeah, those are my tips, and I would say best of luck, and I'll see you at Law Hero for my notes updated for 2025. See you over there.